Ladies and gentlemen, we are what on the Tour de France they call the Lanterne Rouge, that is to say the people who come in last, like the red lantern that traditionally was hung on the back of French trains. My name is Lenny Hoffman. I've been a member of Brick Court Chambers for 13 years, which doesn't come up to Nick Phillips's 50, but is pretty nearly longer than anything else I've done. And we are going to discuss the question of how you determine the law which governs the agreement to arbitrate, which will be explained in greater detail in a moment by Andres Radzitis. Now, we have three highly experienced contributors this afternoon. The first is our own Samir Mulan, who KC, who needs no introduction and will therefore receive no introduction. Secondly, we have, and thirdly, we have two very distinguished European arbitrators, Christophe Serralini, who is a law professor. He is in Paris. He's an avocat de la Cour, and he is a partner in Freshfields. And then we have Michel Potesta, who is a member of the legendary Swiss firm of Levy Kaufmann Kohler in Geneva. First is right.
Andres will introduce.
Oh, of course, yes. Sorry.
My lords, ladies and gentlemen, I have the privilege of introducing the topic for panel 3. When an international commercial contract contains a clause by which the parties agree to submit disputes to arbitration, national law may be engaged in at least three respects. First, as the law governing the contract itself. Second, as the law governing the arbitration agreement. And third, as the law governing the arbitration process. The law of the contract may be expressly provided for in a choice of law clause or according to conflict principles. The law governing the arbitration process is generally the law of the seat. As to the law of the arbitration agreement, however, it is rare to find a choice of law clause specifically governing the agreement to arbitrate. Absent such a choice of law clause, and in circumstances where the law of the contract differs from the law of the seat, what law should govern the scope and validity of the arbitration agreement? That question is the subject of this panel's discussion, and we will hear how the answer provided for in the law of England and Wales compares to that provided for internationally. As to the answer provided under the law of England and Wales, the question came before the Supreme Court in Enka and Chubb. The Supreme Court applied common law conflict of laws principles to determine the law of the arbitration agreement, under which the law applicable to the arbitration agreement will be either A, the law expressly or impliedly chosen by the parties to govern the arbitration agreement, or B, in the absence of such a choice, the law with which the arbitration agreement is most closely connected. The Supreme Court held that the parties' choice of law governing the main contract would generally apply to the arbitration agreement, but that absence any choice of law, the law with which the arbitration agreement is most closely connected would be the law of the seat. It is notable that in reaching these conclusions, the Court's clear focus was on the application of orthodox contractual interpretation principles, with comparatively little discussion on the policy concerns that the decision the Court was asked to determine raises, and in today's discussion you will hear some of those policy concerns. Finally, in reaching these conclusions, the Court also wrought significant change in the applicability of the provisions of the Arbitration Act 96, which apply where England and Wales and Northern Ireland is chosen as the seat of arbitration. The Arbitration Act contains both mandatory and non-mandatory provisions, as many of you will be familiar. Mandatory provisions, which are listed in Schedule 1 to the Act, take effect notwithstanding any agreement to the contrary, whereas non-mandatory provisions only apply in the absence of contrary agreement by the parties. Prior to Enka and Chubb, the law was that non-mandatory provisions were displaced by the parties' choice of law only with regard to the specific provisions in the Act to which the choice of law applies. In Enka and Chubb, however, the Supreme Court held that where England and Wales is chosen as the seat of the arbitration, but the arbitration agreement is governed by foreign law, the effect of Section 4.5 is that all substantive non-mandatory provisions of the Act are automatically disapplied. The distinction between substantive and non-substantive or procedural non-mandatory provisions is identified by the Court as being a difficult distinction to draw, though no guidance is provided as to how to do so. The consequences of the Supreme Court's approach are addressed by our first speaker, Salim Mulan, KC. Thank you.
Thank you very much, Andres. My lords, ladies and gentlemen, the questions this panel addresses arise, therefore, from the Supreme Court's recent decision in Enka and Chubb. The judgment was rendered on the 9th of October 2020, and these consequences are accordingly relatively recent and have to date gone largely unnoticed by the market. They are, however, I would submit, profound and worrying, and I would respectfully submit that they must be, not maybe, but must be, the subject of reform. Indeed, evidence is now surfacing from the courts that parties intent on reneging on their agreements to arbitrate. That is precisely the type of parties which a safe seat for arbitration like London should seek to discourage rather than incentivize, are becoming alive to the myriad of possibilities to disrupt London-seated arbitration, which the Enka decision has opened up and have started using them. Just to draw to your attention that in your pack, and you had that for all panel, but you have the relevant provisions of the Act, Section 4.5, the mandatory sections, the arbitration, the Scottish Act, Section 6, a couple of recent provisions in arbitral rules, and then you've got my outline and the outline of Michele and Christophe, so I may refer to that as we go along. Now, what are the problems that Enka has brought up? There are two aspects to the decision which are problematic. First, the rule that in every London-seated arbitration with a choice of foreign substantive law, the arbitration agreement will be governed by that foreign law. So the first rule in Enka is the way I will refer to that. And secondly, the rule that the effect of Section 4.5 of the Arbitration Act is that that choice of foreign law will automatically displace the non-mandatory provisions of the Act where the provision is substantive and not procedural. That's the second rule in Enka. Let us look at those two rules in turn. So beginning with the rule that in every London-seated arbitration with the choice of foreign substantive law, the arbitration agreement will be governed by that foreign law. Let us take the example of a London-seated arbitration with the choice of Ruritanian substantive law. Now, the starting point is that England strives, as a matter of policy, to be a safe and efficient place for international arbitration, and it has accordingly developed a coherent and substantial body of statutory and jurisprudential principles and rules to support the arbitral process, limit court interference, limit illegitimate challenges to the arbitral awards, and protect the integrity of the arbitral process. These include rules and principles designed to avoid foreign courts interfering with London-seated arbitrations and foreign laws being used to disrupt London-seated arbitrations. Now, the effect of the first rule in Enka will be that all aspects of the arbitration agreement, from arbitrability to the scope of the dispute, of the clause, will be governed now by Ruritanian law. In other words, all the English law principles and rules developed to avoid intermeddling courts and intermeddling laws from interfering with London-seated arbitrations have been done away in one fell swoop. Let's look briefly just at the two issues I just mentioned, arbitrability and scope. Arbitrability. One of the most common ways for recalcitrant parties to impugn the jurisdiction of arbitrators and renege on their agreement to arbitrate is to seek to rely on alleged peculiarities of the substantive applicable law of the contract as making certain matters inarbitrable. So an example from Tamil Nadu, against STCMS, a judgment of Mr. Justice Cook of 2007. You have a contractual dispute as to the tariff for electricity in a foreign jurisdiction. And that will be said to be inarbitrable because the foreign jurisdiction's laws contain a statutory mechanism to determine tariffs, which will more often than not be at odds with the contract, and more often than not, of course, advantage the party from that jurisdiction. Parties choose neutral and safe seats like London in order to avoid such attempts coming to fruition. And English law has developed a robust approach to defeat such attempts. Again, just look at the judgment of Mr. Justice Cook and you will see how that works. But English law now has nothing to say on the issue. The recalcitrant party has a free rein to challenge arbitrability under the applicable substantive law and thus essentially defeat the choice of a neutral and safe seat. This, with respect, goes directly against the policy aim of developing and promoting London as a preeminent seat for international arbitration. Exactly the same issue arises with respect to the scope of the arbitration clause. The decision of the House of Lords in Fiona Trust as to the interpretation of arbitration agreements and the presumption of one-stop adjudication, a landmark of English arbitration law, one lauded the world over, and which has further comforted the place of London as a safe and leading seat for international arbitration, also now finds no application at all. We turn instead to Ruritanian law. And this may or may not contain principles that will assist in having a safe and efficient arbitration. Again, with respect, what good reason can there be for that as a matter of policy for London as a seat? Now, beyond those substantive problems, please consider the practical implications of this. We will now routinely need evidence of foreign law before the court on challenges to jurisdiction, on issues of arbitrability, on the interpretation of the clause, on its scope, on who is bound by it. That is a boon for recalcitrant parties, and the evidence from ongoing applications before the courts at the moment, unsurprisingly, is that such parties have seized this opportunity to disrupt, and that this is exactly what is happening. Again, how does that help London as a safe and attractive seat for international arbitration as a matter of policy? That in itself would justify immediate reform. But matters do not stop there. Let us now turn to the second ruling, that on Section 4.5. Section 4.5, as I said, is in your outline. The position prior to Enka, as you heard from Andres, and you will find that per Lord Justice Longmore in CND, applied by Mr. Justice Burton in Nyock and Crescent, is that, I quote, there has to be a choice of law with regard to the specific provision of the Act which the parties agrees not to apply. A general choice of law was not sufficient. Those two decisions have been expressly overruled in Enka. Now, what are the practical implications of that second ruling? That in every London-seated arbitration, every non-mandatory provision of the Act will potentially be ousted automatically by a routine choice of foreign law. Now, I say potentially because the Supreme Court in Enka expressly recognized that its new interpretation of Section 4.5 would lead to the need to characterize every non-mandatory provision of the Act as either procedural or substantive in order to determine whether the matter dealt with by that section falls to be governed by the default provisions of the Act as the lex arbitri or by the chosen foreign law as the law governing the arbitration agreement. That's at paragraph 80 of Enka. The court expressly recognized that, in the words of the DOC, quoted in Enka, that is, I quote, an extremely difficult and complex exercise, but nonetheless felt that this was the clear legislative intent behind Section 4.5 and thus had to be given effect to. Now, this raises the prospect of having to argue out this notoriously vexed distinction on potentially every non-mandatory provision of the Act going forward. Again, that cannot, I would respectfully submit, be a useful development from the point of view of policy and for the image of London as a settled and safe place for international arbitration. It is an open invitation to unnecessary litigation on what was a previously settled point. Now, the Enka court appeared alert to that particular problem and sought to play down the unhelpful consequences of that part of its decision. And you will find that at paragraphs 91 and 92 of the Supreme Court's judgment, where we are informed, without elaboration, that Section 30, which is competence and is non-mandatory, and Section 58, which is the very important provision that gives final effect to awards, are also non-mandatory. We are told, again, no elaboration, these are procedural. But those specific pronouncements must be obiter. Section 30 and Section 58 were simply not at issue in Enka. Is it so self-evident that those sections are procedural? As we shall see in a moment. In Enka, the court recognized that separability is substantive and not procedural. Why then should competence, which is closely entwined with separability, be treated any differently? And why should the question of whether an award creates final, substantive rights not be considered substantive? Under English law, res judicata is considered to be partly procedural and partly substantive. One can already see the arguments that can be mounted for each of those two sections of the Act. And you can be sure that there will be recalcitrant parties that will in due course be more than happy to do just that and take those points. And beyond those two sections, which the court did address in Enka, what are the multitude of other non-mandatory provisions that were not addressed? What of Section 48 on remedies? Is that substantive? Is that procedural? Section 49, interest, substantive, procedural? What good can there be in introducing this vexed distinction, which the legislator has taken great pains to get rid of, as we all know, in other areas of the law, in the field of international arbitration, where the paramount interest must surely be to promote certainty and efficiency, not unnecessary litigation? And there is, of course, Section 7. As I just noted, the Enka court recognized expressly that that is substantive. It follows that if we go back to our example of a London-seated arbitration with a Ruritanian choice of substantive law, Ruritanian law will govern separability, so that unknown principles, to be adduced by way of foreign law evidence, will govern that central pillar of international arbitration rather than the safe and groundbreaking principles laid down with such force and clarity in Fiona Trust. I would respectfully submit that it is impossible to describe the resulting legal situation as other than terribly disorderly and terribly unhelpful to the perception of London as a safe seat for international arbitration. So what then are the solutions? I've set those out in your outline. The only comprehensive solution is a statutory rule that the law of the seat of the arbitration governs the arbitration agreement, save where the parties have expressly chosen another law in the arbitration agreement itself. That is the position in Scotland, and again, you've got the provision in your outline. A partial solution would be to revert to the previous interpretation of Section 4.5 that will not resolve the serious issues regarding arbitrability, scope ratione materiae, or scope ratione personae. An even more partial solution is to make Section 7 mandatory. That will not resolve the issues I just mentioned. It will not resolve the question of other non-mandatory provisions of the Act, Sections 30, 48, 49, and 58, to name the four of the important ones. As I noted above, it was becoming clear, as the Law Commission's pre-consultation exercise was progressing, that these issues were remaining under everyone's radar. Perhaps because of the relative complexity of the issues, they are complex to some extent. Perhaps also because those consequences were yet to materialize in any meaningful way. So Lord Hoffman, Sir Richard Akins, Ricky Dewan, Casey, and I accordingly raised the issue with the Law Commission in the spring. And it is a matter on which Professor Green and Nathan Temlin, who are both here today, very, very kindly engaged with us. And it soon became clear, however, that the proposal would not be put forward as a recommendation by the Law Commission because it was being raised late in the pre-consultation process and had not yet been identified by others as an issue of concern, but that it would feature as a possible avenue for reform in the consultation paper. It does so in two guises. First, paragraphs 10.3 to 10.10 of the consultation paper puts forward making Section 7 mandatory as a possible, I quote, minor reform. Secondly, paragraphs 11.7 to 11.12 of the consultation paper refers to the introduction of a default statutory rule for the law governing the arbitration agreement as a, I quote, stakeholder suggestion, that's us, the stakeholders, not shortlisted for review, while noting, and as you've heard again from Nick Green earlier today, that no final decision had been taken and that this was all up for debate. The first proposal does appear to be an absolute minimum. It does not, however, and with the utmost respect, begin to deal with the problems identified. So let us look in conclusion as to why this stakeholder suggestion has not been shortlisted for review, and let me seek to substantiate the position some more by reference to those reasons in the consultation paper. The first point to note, and that is incredibly important, is that the question is characterized in the consultation paper as to whether, I quote, whether Enka was wrong. That is not the correct question with respect. The correct question is this: what is the right rule for England and Wales to adopt as a leading arbitral seat as a matter of policy? The answer, it is submitted, is crystal clear, given the consequences of the decision which I've just outlined. As a pure conflicts of law decision, the decision of the Supreme Court is, with the utmost respect, perfectly defensible. Of course it is. But this issue cannot be seen through the narrow prism of conflict of law rules. And that is precisely what paragraph 11.12 of the consultation paper appears to be doing. Now, look, and it's in your outline, look at what Lord Mustill, and you've heard Nick Phillips earlier and Richard Akins refer to him. If there is someone who can guide us on this sort of issue, I would submit it is him. Look at what Lord Mustill told us when the Act came into force in 1996. I quote, conceptually, the Act marks a radical change of direction. No longer are the internal rules to be derived by analyzing the contracts between the parties inter se and between themselves and the arbitrators. The arbitral process is still consensual to the extent that the proceedings would not take place but for the agreement to arbitrate. But by making this agreement, the parties contract into a framework, not chosen by themselves, but imposed by Parliament, save only to the extent that they avail themselves of the opportunity to depart from the semi-mandatory provisions. Yet that's exactly what the Enka Supreme Court does, a purely contractual analysis. The correct question with respect is thus, what makes policy sense for London as a seat, and thus for that framework, the framework referred to by Michael Mustill, set by Parliament, and in which parties who choose London as a seat opt into? To reiterate, it makes no sense to develop a coherent and world-leading body of jurisprudential and statutory principles and rules designed to protect international arbitration inter alia from intermeddling laws and intermeddling courts, to do away with them automatically to the benefit of a foreign law of unknown content, while concurrently handing a new toolbox for recalcitrant parties to slow down or altogether scupper London-seated arbitrations. Another point which comes out of the consultation paper concerns an issue which the Law Commission indicated it would want to see, which is evidence of market practice, of what the market wishes in this area. The first answer to that particular point, do we need evidence of market practice, is with respect that these problems are legal in nature. They do not turn on market practice. But beyond the, with respect, again, unanswerable legal issues, which I have addressed this afternoon, and which the consultation paper does not mention or address, the consultation paper itself contains evidence of what the market desires and of market practice. That is, again, a rule of law that the law of the seat governs the arbitration agreement, save where there is an express choice within the arbitration agreement. And you have that. It comes from paragraph 11.9 of the consultation paper, which refers to the two recent provisions I've put in the outline, LMAA terms, Article 6, and LCIA rules, Article 16.4, which does exactly that. Those rules are referred to in the consultation paper apparently as a suggested solution to the problems I've just outlined, because, as I understand it, what is being suggested is that, oh, you don't need to amend the statute. All you need to do is deal with it in arbitration rules. That, with respect, is misconceived. First, those provisions in market-driven rules have now effectively been ousted by Enka itself for the reasons noted in paragraph 11.11 of the consultation paper, that is, applying the reasoning in Enka, because it's an implied choice of law, it ousts the choice in the rules. So that will not work. Although note that this will yet be another issue for litigation. Secondly, while one can perhaps expect London-centric institutions such as the LCIA, LMA, maybe GAFTA, the grain arbitrations, to take action to resolve these issues by amending their rules, do you truly expect the ICC or UNCITRAL to amend their rules for what is a London problem, which other jurisdiction might actually be quite happy with? Which takes me to my final point. Does London wish to be an essentially local market for international arbitration, catering essentially for English law contracts? Or are we aiming to maintain our reputation and record as a leading seat for international commercial arbitration alongside Paris, Geneva, and Singapore? I ask this rhetorical question because one gets the sense from the consultation paper that there may be a feeling that the scenario that arose in Enka and which I've addressed this afternoon of a London-seated arbitration with a choice of foreign law is really not that common and not an issue worth dealing with. That is, with respect, completely incorrect. There is a lot of English law, London-based arbitration in the fields of shipping, commodities, and construction. The decision in Enka has no bearing on those, but it has huge implications for the large commercial cases for which Paris, Geneva, and Singapore are all vying, and which will almost invariably have a choice of foreign law. The reform which we are proposing is required to maintain London's place at the top table in this crucial field. Thank you very much.
First of all, thank you for having invited me to speak from the French point of view. As Salim explained, the Enka solution raises several concerns and difficulties. Salim has perfectly identified and explained them, so I won't insist, especially because you probably don't want to hear a lesson, especially from French, even with an Italian name and even coming from an English law firm. But what I can tell you is that if you were to maintain the Enka solution without dealing it in your prospective new law, then the French arbitration community will be very happy, since they will see it as serving their own interest and as making France an even more attractive seat than before. And you have that already. I mean, after the debate, the French-English debates about Kabadji, the late Emmanuel Gaillard very quickly wrote an article about the merits of the French approach compared to the completely wrong English one. And indeed, the solution in Enka contrasts with the French approach to the doctrine of separability, whereby, under the French approach, the arbitration agreement is in principle governed by substantive rules established by French courts. And the French approach has been criticized in the past, especially in England, and I won't say that the best one. But his approach adopted in Enka the best solution for a country which is both not convinced by the French approach, but at the same time willing to maintain its position as a leading seat of international arbitration. To answer that question, let's start by reviewing the French approach, then compare it with the English one in Enka, before looking at the conclusion which can be drawn from that. France, as you probably know, regards international arbitration with favor, and this is particularly apparent in the French approach to the doctrine of separability. The principle of separability is a fundamental one in French arbitration law. But it has been so fundamental that it has been given a particular meaning. It started with the quite classical meaning that you can see in the 1963 decision from the French Supreme Court, the Gosset case. It is the separability from the main contract. But it led us eventually to the advent of the substantive principle of, I quote, validity of the arbitration agreement. Indeed, in 1993, the Cour de Cassation, the French Cour de Cassation, went much further and in the Dalico case decided that because the arbitration agreement is separate from the main contract, then as far as its validity and its effects are concerned, no reference to a system of conflict of laws is needed. The validity and effects of an arbitration agreement will only be reviewed with regard to French substantive rules of international arbitration. And these rules are supposed to give full effect to the common will of the parties, subject to the requirement of international public policy, but irrespective of any national law, even the French, I would say, ordinary contract law, and even, of course, the law governing the underlying contract. One has to fully understand the scope of application of this solution. First, it concerns the French judge, and not, at least not directly, the arbitral tribunal. Second, the French judge will apply the French substantive rules to an international arbitration agreement, not only in situations where the seat of the arbitration is in France. As the late Professor Garia explained, French substantive rules are applicable as soon as the dispute is referred to a French court, even in cases where the seat of the arbitration was not in France. For example, it would be the case in a recognition or enforcement action in France. And third, as far as the arbitral tribunal is concerned, in conformity with, that French idea that international arbitrators are delocalized, the arbitral tribunal should be free to apply to the arbitration agreement any law it likes, even truly international principle. But in fact, for an arbitral tribunal sitting in France, the incentive to apply the French substantive rules is very powerful. Why? Because the arbitrator will know that its award on jurisdiction will be fully reviewed by the French courts, and in doing that, the French courts will apply the French substantive rules. So it's an incentive to follow the French substantive rules. This being said, there remains a little window for a conflict of laws approach in France. Indeed, in the Unicode decision of 2004, the French courts of the French Cour de Cassation opened the possibility for the parties to depart from the French substantive rules by expressly submitting the validity and effects of their arbitration agreement to a specific foreign law. However, a choice of law for the underlying contract will not be considered as a choice of law for the arbitration agreement, and therefore will not prevent the application of French substantive rules. And this solution was recently confirmed and clearly confirmed in two cases rendered in 2022, the second of which being the famous Kabadji case from the French Supreme Court. It was the 28th of September that last decision. So as a result, party may depart from the French substantive rules provided under the French code, but only if such derogation is express and unequivocal. And for example, in Could Food, the party choice of English law to govern the main contract was not seen as a choice of law to govern the main agreement and as not seen as a will of the parties to depart from the French rules. Therefore, one could say that even if they are not mandatory for most of them, the French substantive rules nevertheless want to apply as much as possible. And while this approach is said to guarantee the effectiveness of international arbitration, not all jurisdictions endorse it. And indeed, it can understandably be perceived as a form of imperialism. Perhaps the greatest weakness of the French approach is the lack of legitimacy for these French substantive rules to apply in situations where the arbitration had no particular link with France, particularly when the seat of the arbitration was outside France. However, some aspects of the French position may have some merits, notably when the seat of the arbitration is in France. The requirement by the French courts of an express choice of law applicable to the arbitration agreement for departing from the substantive rules will ensure that the exclusion of the French substantive rules was made by the parties deliberately and conscientiously. But before dealing with the potential advantage of the French approach, let's turn to the English one, as I understood it. Your doctrine of separability met a vastly different fate than the French one. In your approach, from a conflict of law standpoint, the arbitration agreement is regarded as part of the main contract, at least when the parties have chosen a law to govern their main contract. Thus, a great deal of importance is placed on the party choice of the law to the main contract, which normally extend to the arbitration agreement. But as perfectly explained again by Salim, that solution raises certain practical issues and concerns. But in any case, this could not be further away from the French approach. As I mentioned before, yes, French courts admit the possibility for the parties to depart from substantive rule, but with two fundamental points. First, the French Code of Civil Procedure contains provisions clearly identifying the provisions which are mandatory and the ones which are not mandatory. And second, and maybe more importantly, the courts make it clear that the exclusion of the French substantive rules governing the arbitration agreement is subject to strict condition, i.e. an express and unequivocal choice of the law to the arbitration agreement itself. I'm not saying that the French method is the best. It might be the best for France, but maybe not for the parties who had, for example, chosen another country as the seat of the arbitration and who might be surprised to see a French judge in an enforcement action in France applying the French rules to the question related to the arbitration agreement. However, be released. You do not need to follow the French approach to maintain London as a leading seat of international arbitration. But where does it lead us? I respectfully submit that if you were to deal with the issue raised by Enka, you may pick up one thing in the French approach. without going as far as the French. You can maintain a conflict of laws approach and avoid most of the issues identified by Salim. Because the good point you can take from the French solution, from a conflict of laws perspective, i.e. the possibility for the party to choose the law applicable to the arbitration agreement, is if you consider the arbitration agreement as a separate contract, or at least as a specific clause in the contract, a clause with a different nature, different subject matter, different purpose than the rest of the contract. Because the main question relates to the implementation of the will of the parties, since arbitration must first be respectful of the will of the parties. And in a contract, in fact, there might be two, at least, expressions of will of the parties. The first expression concerns the main contract and will be expressed in the choice of law clause to govern the contract. But it is not obvious that this expression of will should automatically extend to the arbitration clause. The parties, by choosing the law applicable to the main contract, are concerned with and think about the merits of their dispute. But could you really argue that the party wants the subject to subject the interpretation and the legal regime of the arbitration agreement, which is the basis of the arbitrator's power and of the arbitral process, to the law applicable to the main contract? For example, can you really think that because the party who have chosen London as a seat of arbitration, but who have also chosen French law to govern their main contract, wanted the question of the extension of the arbitration clause to a third party to be governed by French law? I don't think so. In fact, there is indeed another expression of will of the parties in the contract, and it concerns the dispute resolution process. When parties are negotiating an arbitration clause, in practice, their main concern is the seat. Why do they choose a seat? Not for the nice location, not for the food, not for the hotel, but despite what the French may say about this, for the arbitration law and for the arbitration practice of the courts at the seat. Therefore, I disagree with the French approach on that when they consider that an arbitration is delocalized and that the seat does not matter. It does matter for the parties. And it is often subject to hard negotiation between the parties. And I must say that as a counsel, when a client asks me in a difficult negotiation whether he should give up the law applicable to the merits or the seat to the other party, I will answer always, give up the law applicable to the merits, but do not give up the seat, because the seat is the protection of the arbitral process. It ensures, in particular, the effectiveness of the arbitration agreement. And I respectfully submit that this expression of will also, therefore, concerns the legal regime of the arbitration agreement, except maybe, but it's very rare, when there is a third expression of will that will specifically concern the arbitration agreement itself. And if you think about it, the arbitration clause has less connection with the merits than with the arbitral process. In many national laws, the provisions related to the arbitration agreement are not in the contract law of that country, but in the arbitration law of that country. Of course, it leads us to a kind of, I will use a French word, dépeçage. Another part of the main contract, the arbitration clause, that the party can submit to another law, either a law specifically and expressly agreed to govern the arbitration agreement, as required by the French courts, in notably the Chubb case, and on this I agree with the French courts, for once, or in the absence of such a choice, by the law by the law of the seat, which can be seen as another expression of the will of the parties. And here I disagree with the French court. And so I'm not saying that the parties cannot directly choose a law to govern their arbitration agreement. What I'm saying that, first, such choice should be specific and made deliberately in view of the difficulties it creates, and that has been underlined by Salim. And second, that in the absence of an express choice of that particular law, the arbitration agreement should be governed by the law of the seat. And that is a solution that can be seen as respectful of the will of the parties. Thank you for your attention.
Thank you very much, and thank you for the invitation to participate in this very stimulating discussion, which reminded me of a sentence which is attributed to Professor Andreas Löwenfeld, who said that arbitration is comparative law in action. And I think this really gives the idea, this discussion really does give this idea of how arbitration is comparative law in action. And the consultation paper itself is mindful of looking at various jurisdictions, including Swiss law on some points. I will briefly discuss 2 points, which is the law governing the arbitration agreement, especially in light of the concerns that arise out of Enka, and if there is time, I will say a few words also on separability, also to react to the points made by Salim Moulan. You have the relevant provisions from the Swiss law on international arbitration in your bundle of materials. They are the very last 2 pages. I will refer to some of them, but essentially, where I think the PILA, which is the Private International Law Act in Switzerland, is unique, is that it provides a combination of both substantive rules of private international law, therefore directly giving a certain solution on a certain issue. I'll give a couple of examples, and conflict of law rules, but of a certain type, as I will be discussing in a moment. And the result of this combination is that the framework that is created is deemed very arbitration friendly and very predictable for its users. Now, most of the instances in which one seeks to identify what law governs the arbitration agreement, which is our topic, is to ascertain whether the arbitration agreement is valid. And from a Swiss perspective, in order to be valid, an arbitration agreement should, before anything else, refer to a dispute that is arbitrable in the continental European sense that Salim was referring to before, a dispute that is capable of being settled by arbitration. And differently from the situation that I understand now arises from the Enka decision, Swiss law is very clear. It provides a substantive rule of private international law, therefore directly giving a definition of what is arbitrable, and which is very broad. Essentially anything that is financial in nature is arbitrable. And so the problem doesn't even arise. There's Article 177, paragraph 1. And 177, paragraph 2 provides a rule concerned with states and state-owned entities. When a state or state-owned entity is sued before an arbitral tribunal acting under Swiss law, this rule prevents the state or the state-owned entity from invoking its own law to contest its capacity to be a party to the arbitration, or from raising as a defense that the dispute is not arbitrable. Again, a substantive rule that addresses directly the question. Third rule of substantive rule, form, Article 178.1. Swiss law gives you the answer, and it's very simple. An arbitration agreement must be simply evidenced by text. Now I go to the core of my observations, which concern substantive validity, and that's addressed. You have it in the materials in 178.2, and that's the Swiss law addresses it through a conflict of law rule in favorem validitatis. And that's a very interesting, I think, approach to be discussed, especially for the comparative law exercise that we are doing. Essentially, what 178.2 says is that as regards the substance, so for instance, if there is consent, if there is an offer or acceptance, an arbitration agreement is valid if it conforms to at least one of three possible laws. One is the law that the parties have expressly chosen to govern the arbitration agreement. We know it's rare, but it may happen. Second, the law of the main contract, the lex causa, the lex contractus. And third, Swiss law. I'll refer to this rule rather than you can keep using the Latin phrase as, for simplicity, as the validation principle under Swiss law, not in general terms. And this validation principle obviously has a very strong pro-arbitration bias. That is, it indicates Switzerland's policy to support the validity of the arbitration agreement as much as possible. And by the way, we are not alone in following this approach. Other jurisdictions do the same, the Netherlands, Spain, Portugal, Croatia, Algeria, among others. And in his Hague lectures, Professor Berman explained the rationale for the validation principle in his characteristically lucid terms. He said, the premise underlying the validation principle is a realistic one, namely a party does not enter into a commercial contract containing an arbitration agreement anticipating that the existence or validity of the agreement will be governed by any particular body of law. What they anticipate instead is that the arbitration agreement will be upheld and enforced. And so an arbitration tribunal seated in Switzerland will find, or needs to find, must find that an arbitration agreement is valid if it conforms to at least one of the three laws. Mind you, it's not an invitation to go and find any law out there in the world that will validate the arbitration agreement. It's rather under one of the three laws that are most presumably connected to the arbitration agreement, in which are the three that are indicated in the provision. And as I've said, the first one is the law chosen to govern the arbitration agreement. The second one is the law of the main contract. And the third is Swiss law, which is the law of the seat, because, of course, Chapter 12, which is the Swiss arbitration law, applies if the seat is Switzerland. And you can notice that the first and third of these two laws, the law chosen by the parties to govern the arbitration agreement and the law of the seat, are the same as in 5.1a of the New York Convention, so there is an overlap there. But Switzerland goes further and allows to validate, as I said, under a third law, which is the law of the main contract, which is not included in 5.1a. This means that in some cases, in some situation, you could have an agreement that is invalid under Swiss law and the law chosen by the parties to govern the arbitration agreement, but is nevertheless valid under the law of the main contract. And therefore, the arbitral tribunal would uphold jurisdiction in Switzerland, but of course, the award, there might be a risk that the award might not be enforced elsewhere because 5.1a does not include as a connecting factor this third one that I've mentioned. And that's a risk that the Swiss legislator deliberately accepted when enacting this provision, and again shows the pro-arbitration stance that is followed. And here I see really a key difference with as I understand the English approach, which is to look with a rather complex exercise in this conflict of law analysis under English law. Is it the law of the seat? Is it the contract? What's the implied choice? Under Swiss law, essentially, you can do away with this conflict of law analysis because you just care about the result. You just need to satisfy yourself that the arbitration agreement is valid under any of the three laws that are putatively connected with the arbitration agreements. Now, Swiss law goes even one step further and consider this situation. What happens if the parties have chosen a law to govern the arbitration agreement that leads to nullity, that leads to invalidity? Of course, this is a rare situation in practice. It's rare that the parties in the first place choose a law to govern the arbitration agreement, and it is even more rare that they choose a law that would lead to the invalidity of the arbitration agreement. But if that happens, Swiss law, by its statutory provision, allows to validate nevertheless the agreement if it conforms to either Swiss law or to the law governing the substance. So there's obviously a tension between party autonomy that is expressed by a choice of law that leads to invalidity and the solution that is enshrined in Article 178.2, which is the validation principle, and which the Swiss legislature resolves in favor of arbitration. And we can discuss whether this is because we try to identify the real intent of the parties, that is to say their intent was to arbitrate and therefore their choice of law governing the arbitration agreement was in reality a mistake. This is what Gary Bourne would say. Or whether it's just acknowledging that it's a policy choice of the Swiss legislator that allows party autonomy to give way to a solution, to rules of the legal framework to protect arbitration. And let me just draw a final conclusion on this issue with the validation principle, as I understand, was discussed in Enka by both the majority and the minority. The Supreme Court framed the validation principle under English law as one of contractual interpretation. You have the formulation in paragraph 106 of the judgment. I will not read it, but as I understand it, and you all, of course, will correct me if I say something wrong on this under English law, but as I understood it from reading the judgment, the validation principle only comes up in case there is no express choice of law governing the arbitration agreement. The minority says it very tersely at paragraph 257. It says, where there is an express proper law clause in the arbitration agreement, which is rare, that will be determinative. And so, as I understand it, the validation principle under English law is said to operate at the implied stage, choice stage, favoring the implication of a law validating the arbitration agreement to give effect to the parties' agreement to arbitrate. Now, if that is right, the validation principle would not be able to override an express choice of law to the arbitration agreement that has been made by the parties. And again, here's a difference with Swiss law, because as I've just explained, the validation principle does allow to override that express choice of law. If I have 2 more minutes, I can speak about separability, because it's indeed an interesting topic, and Salim has also addressed it. The consultation paper has a section devoted to separability. There's even a question that is asked, question 28, where the consultation paper asks whether Section 7 of the Act should be made mandatory, and if so, why? And then the consultation paper says that separability is mandatory under certain foreign legislation, and refers to Swiss law in a footnote. And actually, the position is a bit more nuanced than that, and I'll try to briefly explain why. And the background to this has been already explained by Salim, and it is, of course, the ruling of the Supreme Court in Enka on Section 4.5 and the holding that separability, as I understand it, is substantive. Again, Swiss law deals in the matter in my humble view, much more neat and direct way. It has a rule, again, a substantive rule of Swiss private and international law in the Act, 178, paragraph 3, which immediately follows validity, and exactly provides that in those cases that Salim was referring to, where there is in our case would be let's say a Swiss-seated tribunal, but a choice of law to the main contract for Ruritania, and assuming Ruritania does not recognize separability, Swiss law kicks in and provides that no matter what, separability does apply. It doesn't mean that the provision is mandatory. Parties, at least under our Supreme Court's holding, parties are allowed to opt out from separability. The Supreme Court said it very clearly, although it was not an obvious outcome in my view, but the case law is clear in the name of party autonomy in this case. But to opt out, you need something much more than just a reference to a foreign choice of law clause to the main contract. You would probably either need express language that would say we link the fate of the main contract to the arbitration clause or vice versa. So you're expressly opting out of what is the equivalent to Section 7 in our arbitration law, or you make an express choice to the law governing the arbitration agreement, and which law does not recognize then separability. So again, quite a different, in my view, position from the English law, and one that seems to me to benefit greatly Switzerland as a safe and efficient place for arbitration. Thank you very much.